Good evening and Jai Bhim friends. Welcome to Digital Nalanda. Today we are going to start our new course, an introduction to the Indian constitutional law by our friend Preethi L.N. Before giving her introduction, I just wanted to tell you a little bit about Digital Nalanda because many of the students are quite new to our platform. So since last 1 year, we have been running this online learning platform called Digital Nalanda. And the idea behind this platform is that we want to create a platform where we can disseminate the knowledge without any constraint, especially financial, because the experience of our community student is that most of us want to gain knowledge, but there are so many structural constraints are there, and we are not able to get access to the knowledge. So the whole idea of Digital Nalanda is that educators from our community, those who have enough experience and exposure, they come and share their knowledge and experience with our students. So in this way, we have been trying to build this platform. So we run a number of schools, different subjects. We have arts, School of Art, School of Design. We have management school. We have also started giving training to students who are preparing for medical exam. So in this series of initiative, we also thought that we should develop our School of Law. So last 1 year, we have been running this school, and till last month, we were running this CLAT coaching program. So those students who come from a non-English medium background, from rural areas, we try to help them to prepare for CLAT. So in this, we have started this new course where our friend Preethi will introduce you to Indian constitutional law. So I want to welcome Preethi. Preethi is an old friend of Nalanda. I know her since her student days, and she has been very active in the movement, and she's a great scholar. She completed her graduation from National Law School, Bangalore, and she won gold medal there. And then she went to UK and did her LLM, and now she is pursuing her PhD from Lancaster University. So I welcome Preethi. It's an honor to have you in Digital Nalanda, and Preethi, apart from this course, has already been mentoring our students, those Nalanda alumni who are in law schools. So she has been engaged with Digital Nalanda since some time. So I'm very happy that she agreed to start this course. So thank you so much, Preethi, and I welcome you. And apart from this, I wanted to tell you that this course is being hosted in the Digital Nalanda. So apart from the live sessions, we are recording all the videos, and we will be putting it on our school page, School of Law page. So one can access, even after this live session, one can go and look at those videos. And also we will be giving readings and presentations that also will be uploaded in PDF form at the School of Law page. So any of the students who wants to access those can go and access there. So this is the information I wanted to give it to you. Over to you now, Preethi, and welcome to Digital Nalanda.
Thank you so much, Bhai. That was very kind. Thank you. And wow, hello everyone, Jai Bhim. Well, I don't know what to say. I'm really happy to be here. And I'm happy that you all are here. Thank you very much for being here. I hope to see you all in the coming weeks as well. I don't claim to be an expert in constitutional law. However, I know a thing or two, and I'm happy to share them with you. About my relationship with constitutional law, I worked with the sitting Supreme Court judge as a law clerk when I was a student, where I assisted his lordship in writing judgments on cases relating to constitutional law and international law. And then I taught constitutional law for a couple of years at NLS Bangalore. So that's about it, really, nothing huge. So it's practically impossible to teach constitutional law in 20 hours or any course for that matter, I suppose. So this course is basically designed to introduce you to core concepts and principles in constitutional law. So you can learn to interpret the provisions yourself to, to benefit weaker and marginalized sections. Right. So I think we're good to go. We'll start now. Okay. Right. And I'm sorry, I don't have a PPT or something. I'm really old school. So you might as well want to have a pen and a paper so you can have little notes, and the rest of it would be uploaded in the digital Nalanda website. And right. So Constitution is a set of fundamental principles according to which a state is governed. At this point, I'll have to tell you that if I have to speak for a long time, then I'll be really tired and it'll be really boring. So in order to avoid this monologue, I would want you all to take part as well. So I'll try to make it as interactive as possible. And I want you all to speak as well, right? So as I said, Constitution is a set of fundamental principles according to which a state is governed. So what is a state? Who's gonna answer that? I'm sure a lot of you have studied political science, and there are quite a few of you here who are law students. So go on, put up your hands, so then we'll see who can answer that. What is a state? I know that there are students of Nalanda here. Yes, Santosh? No? Anyone else? Come on, this is not even hard. No one? Yes, please tell me what state is, Santosh. You all are putting up your hands.
Santosh, you can unmute yourself and speak.
Yes, now I am audible, ma'am.
Yeah. Please.
Madam, state is which the government has a right to take decisions for their welfare.
Right.
They can take any decision
Okay.
for their welfareness, goodness, and for their security and other things.
All right. What about somebody else has got hand up? Thank you, Santosh.
State is a body to which we give power to run the country or run the some geographical area.
Right. Anyone else? That's it? There are 79 students. All right. Leave me. There are 78 students. Mayank?
Satindwar, you can speak.
I think he's spoken already.
Okay.
Mayank?
Mukul Raj.
Hello.
Yes. Who is? Yeah, Mayank, go on.
So basically, state is an entity where it has a fixed territory, fixed population, laws, and a government which runs which make rules and runs the government in that territory. So that's what state means.
All right. That's pretty close. So under international law, there's a convention called as the Montevideo Convention on the Rights and Duties of States, 1993. That's Montevideo is Montevideo. It's a place, it's the capital of Uruguay. So this convention is called the Montevideo Convention on the Rights and Duties of States, 1993. It basically lays down the criteria for statehood. So accordingly, according to Article 1 of this convention, a state must have 4 important components. First, there must be a permanent population. Second, there has to be a defined territory. Third, a government. And fourth, the capacity to conduct international relations with other states. So modern state is much more than a police state or the one that focuses only on law and order. It aims to be a welfare state. So welfare state is a state which renders social services to people and promotes their general welfare. So in order to carry out its activities and functions, whatever maybe their range, it becomes vital for a state to establish certain basic organs or agents or instrumentalities which act on its behalf and through which state can function and operate, right? So all the people in a state cannot operate together, and hence certain fundamental organs become necessary. And this creates the need for constitutional law. There must be a predictable body of norms and rules from which the governmental organs must draw their powers and functions. So the purpose of having a constitution is to, have a framework of government which is likely to endure through the transformation of a nation, something which can withstand the hard times. So legal system of a country is divisible into two. One is a law that governs it, like basically the law governing the state. And the other is a law by which the state governs or regulates the conduct of its members. So the first one is called public law. So who can tell me some examples of what public laws? You must have heard about public laws. So what are public laws? Some examples of public laws. I'm sure this is much of it is a repetition to my students from Nalanda. So somebody just give me some examples of what public laws you've heard. Hands up. Right. Answers in the Constitution.
Ma'am, public law, ma'am, in public law, the relationship between public law deals with the relationship between state and citizens, ma'am, majorly.
Right. Examples. Examples for public law.
Ma'am, the Right to Information Act is a public law. Ma'am, all administrative laws are public laws. So, ma'am, yes.
Right. So we have constitutional law, administrative law, public international law. So basically these all come under public law. And then there are private laws. So can you give some examples for private laws? It's not that hard. Non-lawyers also can answer. Come on. It's basically the relationship between, yeah. Right. There are some answers in the chat box. Right. Contracts, torts, property, intellectual property rights. So these are some of the examples for private law. So generally speaking, the constitution of a country seeks to establish the fundamental or basic or apex organs of government and administration, describe their structure, composition, powers and principles, functions, define the interrelationship of these organs with one another, and basically try to regulate their relationship with the people, and particularly political relationship. So we've named this, now you know what constitution is, and we've named this course as Constitutional Introduction to Constitutional Law. So what is constitutional law? Right, that's a question. Hands up. Yes, no, something. Nothing. No answers.
Hello, ma'am.
Yes.
Am I audible?
Yeah, please go ahead.
The Constitution law is the body of rules, doctrine, and practices that governs the operation of political communities.
Right, that's right. So constitutional law is basically a more broader term than constitution. It comprises of the constitution, relevant statutory laws, judicial decisions, and conventions. A constitution is a unique legal document. It enshrines a special kind of norm and stands at the top of the normative pyramid. Difficult to amend, it is designed to direct human behavior for years to come. It shapes the appearance of the state and its aspirations throughout history. It determines the state's fundamental political views. It lays the foundation for its social values. It determines its commitments and orientations. So traditionally, the structure of a country's government is divided into three institutional components. One, the legislature to make laws. Two, the executive to implement and execute laws. Three, judiciary to interpret laws and administer justice. So the Constitution deals with questions such as how is the legislature structured, composed and organized, what are its powers and functions, and similar questions in relation to executive and judiciary. So there are other questions such as the mutual relationship between the organs and relationship between the organs and the people. Does Constitution guarantee any rights to the people? So these are the questions which the Constitution deals with. So our Constitution also creates other organs, like there's Finance Commission, Election Commission, there's National Commission for Scheduled Castes, there's National Commission for Scheduled Tribes. So these are the commissions which are created with specific purposes. Now coming to another significant aspect of a relationship between the government and the people is guaranteeing of certain fundamental rights to the people. So the underlying idea is that there are certain basic rights inherent in a human being and which no government should seek to take away either by legislation or by executive action. So the judiciary acts as a custodian of the fundamental rights. It's endowed with powers to protect them. If the legislature passes any law or executive action which infringes the fundamental rights, the courts have the power to declare them as unconstitutional. So I hope this is clear so far. If you have any questions, then we'll see towards the end of this session. Right. So coming to the nature of the Constitution, there are two kinds. There's Unitary Constitution and Federal Constitution. So who's going to tell us what a Federal Constitution is? Anyone? No one? Federal Constitution? It's
You
not
can
that
raise your
hard.
hands.
In federal state, when there's a division of power between the provinces and the federal government. So there's a government at the center, and there's a government at the state level. So
Right.
there's a distribution of power.
Right.
Division of power.
Right, that's right. So in a federal constitution, there is a central government having certain powers, which it exercises over the entire country. Then there are regional governments having jurisdiction over particular regions. So in India, what we call as state governments. So examples for federal constitution include our own, and then we have US, Canada, Malaysia, Australia, Germany, and so on and so forth. And what about unitary constitution? Anyone? What's a unitary constitution? The exact opposite. Yeah, Mayuri.
Mayuri.
Ma'am, it is the only central who rules.
Sorry?
It is the central government.
Right.
In
Right.
it.
That's right. So in a unitary constitution, there is one central government and it has all the powers. It can delegate to any of its agencies as it likes. So the best examples for unitary constitution include Britain, Sri Lanka, and Singapore. So, right. Yeah, sorry, I was just seeing the chat box. Now, constitutional law of a country consists of both legal and non-legal norms. So legal norms are applied and enforced by courts, and if there are any violations, the courts can give relief. Non-legal norms arise due to certain practices followed over and over again. Such norms are known as conventions, usages, customs, and practices of the Constitution. So in national law, we have something called as customary international law. And similarly, in constitutional law, we have non-legal norms. There might be nothing in the Constitution sanctioning them. Nevertheless, they exist. In the words of Sir Ivor Jennings, quote, thus within the framework of the law, there is room for the development of the rules of practice, rules which may be followed as consistently as the rules of law, which determines the procedure which men concerned with government follow, unquote. So commitment to the Constitution is a facet of constitutional morality. We should remember that Constitution is written in blood rather than in ink. So Baba Saheb rightly pointed out that constitutional morality is not a natural sentiment. It has to be cultivated and nurtured. We must learn to develop reverence for the Constitution and the constitutional structure and the values it stands for. So according to Keaton, conventions of the Constitution are the unwritten principles which, though they could never be enforced as law in the courts, are nonetheless rules, since in fact the players of the constitutional game do observe them. For if they are not observed, the constitutional game would immediately degenerate into a political fracas, or worse still, a bloody revolution. So the sanction behind conventions is mostly political or public opinion. So C.J. Ahmadi observed that conventions grow from long-standing accepted practices or by agreement in areas where the law is silent. And as such, convention would not breach the law, but fill the gap. So it's very important to note that the conventions do not breach the law, but they have to fill the gap. So constitutional conventions provide the flesh which clothes the dry bones of the law. So conventions play a major role in unwritten constitutions like that of Britain's. In India, they operate in several areas, more significantly in the relationship between legislature and executive. So a constitution may be written or unwritten. A written constitution is where it's written down in the form of a constitutional document. And unwritten constitution, the best example is that of the British Constitution, where it is not embodied as one comprehensive document. It's contained in several statutes, which define some key constitutional principles in court decisions, in common law principles, and in conventions and usages. So the central document of the British Constitution is the sovereignty of the Parliament. That is, the Parliament can make or unmake any law, and no distinction is drawn between ordinary law and constitutional law. Example for unwritten constitution apart from Britain is that of China, Israel, Saudi Arabia, New Zealand, and they're also called as uncodified constitution. And then there's written constitution. So the best example is our own. And then we have US and Australia. So a written constitution is a formal source of constitutional law in the country. It is regarded as the supreme or fundamental law of the land. It controls and permeates each institution in the country. Every organ of the country must act in accordance with the Constitution. Any exercise of power outside the Constitution is unconstitutional, and any law made by legislature or any action taken by the executive, if found to be inconsistent with the provisions of the Constitution, can be declared as unconstitutional by the courts. So basically, the Constitution is an organic, living document. Its outlook and interpretations must be dynamic and must change with the changing times. So the basics are fundamental and unalterable. Other provisions can be interpreted to help the needy and weaker sections. So the courts are regarded as the interpreters and guardians of the Constitution. It is the obligation of the judiciary to see to it that the Constitution is not violated by any governmental organ. So there is a need for special provisions for amendment of Constitution in a written Constitution. that's why we consider written constitution to be rigid as opposed to unwritten constitution, which is called flexible, as it can be changed by ordinary legislation. Now, we come to the concept of constitutionalism. So who is explaining us what constitutionalism is? Let me take a small break. Please go ahead. Constitutionalism.
You can raise your hands.
Come on, this is not hard. Law students at least. Shubham, right. Go on.
The Constitution is the bare text and Constitutional.
Little louder, Shubham, please.
The Constitution is a bare text and Constitutionalism is the study of the concept and aspects related to the Constitution.
That's constitutional law. Constitutionalism is a concept, right? So that's slightly out. Mayuri?
Mayuri.
Hello, ma'am.
Yes.
Ma'am, it is the government according to the constitution, separation of powers and sovereignty of the people and democratic government.
Right. Okay. Mayank?
Hello, ma'am. Okay.
Yes.
Basically, constitutionalism is where the powers are power and authority gain their power from constitution. That's constitutionalism.
Okay. Let me hear it from somebody else. Who else is remaining? Mukul?
Constitutionalism, deals about limitation on powers of the state. Not only state, ma'am, in Indian context, it also, ma'am, Article 17, it's horizontal limitation on powers. So, ma'am, it's a restriction of power of the state and also the citizens.
That's right.
There are limited powers.
That's properly. Yeah, that's fine. So, as who was it? Mukul, right? So, yeah, Mukul was right. So, a country may have a constitution, but not constitutionalism. So the best example is Nazi Germany, where Adolf Hitler was a dictator and his word was a law. There was a constitution, but there was no constitutionalism. So the underlying difference between the two concepts is that a constitution ought not merely to confer powers on various organs of the government, but also seeks to restrain those powers. So constitutionalism recognizes the need for government, but insists upon limitations being placed upon governmental powers. So constitutionalism envisages checks and balances and putting the powers of legislature and the executive under some restraints and not making them uncontrolled and arbitrary. So unlimited powers, they jeopardize people's freedom. As John Dalberg Acton once said, power corrupts and absolute power corrupts absolutely. So if unrestrained power is conferred by the constitution on either the legislature or executive, it might lead to an authoritarian, oppressive government. Hence, to preserve the basic freedom of the individual and to maintain his dignity and personality, the constitution should be permeated with constitutionalism. It should have some inbuilt restrictions on the powers conferred by it to the governmental organs. So in essence, constitutionalism connotes limited government or a limitation on government. It is the antithesis of arbitrary powers. Constitutionalism recognizes the need for government with powers, but at the same time insists that limitations be placed on those powers. So the antithesis of constitutionalism is despotism, tyranny, or dictatorship. So only when the constitution of a country seeks to decentralize power instead of concentrating at one point and also imposes other restraints and limitations does a country have not only constitution but also constitutionalism. So the idea of constitutionalism is not new. It is deeply embedded in human thought. So many natural law philosophers, like I'm sure many of you have studied in jurisprudence or in political theory, natural law philosophers like Thomas Aquinas, Paine, Locke, Grotius, and Rousseau have promoted this idea through their writings. The Magna Carta, which is a 1215 document guaranteeing English political liberties, which basically said that the king must follow the law. And it's the first document to state that citizens had rights. So basically, Magna Carta strengthened the traditional view that law is supreme. As Arthur Sutherland observed, that the Great Charter, being the Magna Carta, was obviously a cherished standard, a welcome assurance that people could set some limitations on the arbitrary power of the king. So, what are the principles that promote constitutionalism in any country? Now we know what constitutionalism is. What are the principles that promote constitutionalism in a country? Go on, who's answering this? Yes, no, something, nodding, something. So I'm not speaking alone. Nothing. All right. So we have a written constitution, independent judiciary with powers of judicial review, the doctrine of rule of law and separation of powers, free elections to legislature, accountable and transparent democratic government, fundamental rights of the people, federalism, and decentralization of power. So these are the principles which promote constitutionalism in a country. Now we will come to rule of law. Sorry if I'm rushing because there's a lot to cover and there's less time. And right, so we're going to rule of law. So the doctrine of rule of law is ascribed to A.V. Dicey, that is A.V. Dicey, who's writing in 1885 in a book called The Introduction to the Study of Law of the Constitution. The writing was on British Constitution. It included 3 distinct, though kindred ideas in rule of law. One is the absence of arbitrary power. So no man is above law. No man is punishable except for a distinct breach of law established in an ordinary legal manner before ordinary courts. So the government cannot punish anyone merely by its own fiat. Persons in authority in Britain do not enjoy wide arbitrary or discretionary powers. Dicey asserted that wherever there is discretion, there is room for arbitrariness. Second is a concept of equality before law, where every man, whatever his rank or condition is subject to ordinary law and jurisdiction of ordinary courts. So no man is above law. And third is the individual liberties, where the general principle of British Constitution and especially the liberties of the individual are judge-made. That is, these are the result of judicial decisions determining the rights of private persons in particular cases brought before courts from time to time. So the British Constitution is judge-made and the rights of the individuals form a part of and they pervade the Constitution. So the rights of the individuals are part of the Constitution because they are secured by the courts. So the British Constitutional is not this, the British Constitutional law is not the source, but the consequence of rights of the individuals as defined by the courts. But Dicey's thesis has been criticized by many from various angles. But the basic tenet expressed by him is that power is derived from and is to be exercised according to law. So in substance, Dicey's emphasis on the whole in his enunciation of rule of law is on the absence of arbitrary power and discretionary power, equality before law, and legal protection to certain basic human rights. So I believe these rights and these ideas remain relevant and significant in every democratic country, even to this day. But with the passage of time, things have changed in many democracies. There have been a universal growth of broad discretionary powers in administration. There's preventive detention in many countries. But the basic principles and ideas which Dicey has propounded are worth preserving and promoting. So rule of law does not simply mean ruling according to statutory law, because statutory law may itself be harsh, inequitable, or discriminatory or unjust. So rule of law connotes some higher kind of law, which is reasonable, just, and non-discriminatory. So rule of law today envisages not arbitrary power, but controlled power. So constitutional values such as constitutionalism, absence of arbitrary powers in the government, liberty of the people, independent judiciary, and so on and so forth are these concepts which are imbibed in the concept of rule of law. So the Indian Constitution seeks to promote rule of law through many of its provisions. Like we have democratic elections to parliament through universal adult suffrage. We have independence of judiciary and judicial review as well. So the Supreme Court in Minerva Mills versus Union of India, it is a 1980 case, that is MINERVA MILLS versus Union of India. It's a 1980 Supreme Court judgment. It held that judicial review is a basic structure of the Constitution, which is unalterable. So judicial review is the basic structure of the Constitution. And Article 14, which we will study in due course of time, guarantees equality before law. In Bachchan Singh versus State of Punjab, that is BACHAN SINGH versus State of Punjab, it's a 1982 judgment by the Supreme Court. Justice Bhagavati emphasizes that rule of law excludes arbitrariness and unreasonableness. To ensure this, he suggested that it is necessary to have a democratic legislature to make laws, but its powers should not be unfettered, and that there should be an independent judiciary to protect the citizens against excess of executive and legislative power. So in modern times, two great values emanate from the concept of rule of law. One is no arbitrary government, and two is the upholding of individual liberty. So in another famous constitutional law case of ADM Jabalpur versus S. Shukla, that is ADM JABALPUR, ADM Jabalpur versus S. Shukla, 1976 judgment of the Supreme Court. Justice Khanna observed that the rule of law is the antithesis of arbitrariness. So rule of law is now the accepted norm of the civilized societies. Everywhere it is identified with liberty of the individual. It seeks to maintain a balance between the opposing notions of individual liberty and the public order. So in every state, the problem arises of reconciling of human rights with the requirement of public interest. So such harmonizing can only be attained by the existence of an independent judiciary. So these independent courts, which can hold a balance between the citizens and the state and compel governments to conform to the law. So judicial review is a significant derivative of the rule of law. It is an essential part of rule of law. It basically involves determination not only of constitutionality of law, but also of the validity of administrative action. So judicial review is extremely important. So the actions of state public authorities, bureaucracy are all subject to judicial review. So they are all done, they are all accountable to the courts for the legality of their actions. So then there is State of Bihar versus Subhash Singh. It's a 1997 judgment where the Supreme Court held that judicial review is a part of the basic structure of the Constitution, and it cannot be done away with by even exercise of any constituent power. So that is about rule of law. I think we should stop it here. If there are any questions, I'll be happy to take them. Anything? Yes, no? Am I fast, slow? Something, so I understand what's happening here. Yes.
Yes, Satvinder.
Ma'am, how a country run where there is no written constitution?
They have conventions. So they have conventions, they have judicial decisions, customs, usages. There are other laws as well. So they all become part of constitutional law. So what the judgments are very important in places where there are no written constitutions, especially in Britain.
Okay, if there is a conflict, then the court judgment decide the.
Yeah, the court's judgment is the one which they have to look for. That's why the courts have a lot of power, and then the parliament is supreme. So the sovereignty of parliament is the fundamental of British Constitution. So they have the parliament has a right to make or unmake any law.
Preethi, Medha is asking on chat, can you share some literature which will simplify things for us?
All right. There are books. There is B.N. Shukla's Constitution of India. And
Students, please, you have to write when she's saying something, okay?
Yeah, please do write. So there's B.N. Shukla's Constitution of India. And there is MPJN, Indian Constitutional Law. These two books should be enough to understand the basics of Indian Constitution. You don't have to refer to SERVA, it's really complicated.
Vidisha is saying, please repeat the important cases you just mentioned.
All right, the cases. Did I start with? I think I started with Bachchan Singh, or did I? Oh, I think I started with Minerva Mills. So Minerva Mills is MINERVA MILLS versus Union of India. It's a 1980 decision of the Supreme Court where judicial review is held to be the basic structure of the Constitution. Then there is Bachchan Singh versus State of Punjab, BACHAN SINGH versus State of Punjab. It's a 1982 decision. Right? Then there is ADM Jabalpur versus versus S. Shukla. That is a 1976 judgment of the Supreme Court. Then there is State of Bihar versus Subhash Singh. That is SUBHASH SINGH. It's a 1997 Supreme Court decision. So there are about 4 cases.
Preethi, Pranav is asking, does the authority of Constitution come from the people or is it the other way?
No, the authority of the Constitution emanates from the people of India, Indian Constitution especially. So that we are going to cover in the next session, where it's written, the first thing you see in our preamble itself is we the people of India give to ourselves. So basically the sovereignty of the powers and everything lies with the people, and it is from the people that the powers of the Constitution come from. Indian Constitution especially.
There is one more question for the beginners. How we can understand the path of Constitution?
You have to read. You have to read a lot. So you have to start reading by commentaries on Indian Constitution, and when you read your read the commentaries, don't blindly read it. Understand what they're trying to say, because a lot of the commentaries are written from a particular ideological point of view as well. So it's very important when you're understanding And interpreting laws, you know how the author interprets, and there is no right way to interpret a law. So you should know that there are multiple ways to interpret a law. So what is written in the book may not be the sole way of interpreting a law or a provision, or what the judge says may not be the only way in which you can interpret the constitution. There might be several other ways which are not explored. So when you're reading these books, make sure that you learn to interpret these provisions. Each word carries weight, even may and shall carries weight. So understand that these each words are when used in particular ways, the meaning of the provision changes. So reading is very important, and start by reading commentaries on the Constitution and case laws, of course. So you'll find case laws in commentaries of sorry, Mayuri.
Kavya is asking, are there individuals or groups that are immune to prosecution regardless of crime offense committed?
There are there are different procedures. For example, you can't directly file a case against the President of India or the Chief Justice. There are different procedures, but they're not immune from anything. So Article 14 says equality before law, so everyone is equal. So just because somebody is holding a position of power, or somebody is considered to be the first citizen of the country, he is not immune from anything. No, he is just as much a citizen of India, and is just as much governed by the same fundamental law of the land as any one of us.
Mayuri, I'm unmuting you. You can ask the question.
Hello, ma'am.
Yeah.
I have a question that how and why the Constitution is called as a social contract.
Because it is something which which we are going to learn in the next session, where the preamble itself, where the people are giving to themselves. So that is the basic fun. Our Indian Constitution is something which is emanating from the people. It is not something which is from the king or from God or some religion. It's not that way. It is coming from the people, and the sovereignty lies within the people. So people are the supreme. So we, the people of India, give to ourselves. So that is a fundamental of it. So that's what we are going to study in the next session.
Preethi, Kanika is asking, does judicial review being part of the basic structure of Constitution violate the principle of supremacy of legislature above the other two pillars of democracy? Question mark.
No, it doesn't, because the concept of basic structure is where, because a lot of things, say for example, preamble or fundamental rights, part 3, or democracy for that matter, are held to be, this whole concept of basic structure is something which is judge made. So these are all something which cannot be violated. So the fact that judicial review is held as basic structure, I don't think how it can violate the supremacy of the legislature, because I understand where you're coming from. I totally get that parliamentarians, say 500 parliamentarians are sitting and making a law, and there's a single judge in the Supreme Court who can say that it is unconstitutional. But the problem, the fundamentals with this is that the judge can't simply say that it is unconstitutional. The judge has to say it based on the Constitution. So the supremacy of the Constitution is what that is going to be held on top here. So when the judge declares something as ultra vires the Constitution, it is ultra vires the Constitution. So the Constitution is supreme there. So anything below that is obviously having that status below it. So I don't think it violates that principle of supremacy of legislature. No, I don't think so. And there might be some other opinions. I'm welcome for that. So personally, I don't think it is.
Pranav is asking, doesn't laws like AFSPA go against the principle?
Which principle?
Pranav, if you want to ask this question directly to Preethi, you can raise your hands. Pranav, if you want to clarify this question. Pranav is here. Pranav.
Principle of equality. No, we haven't come to that yet. We haven't come to that yet. Be patient. When we come to principle of equality, we will discuss that. Now we are still in the basic concepts of constitutionalism and rule of law. So once we come to Article 15 and 16 and 14 and everything, we'll see to it that time. So anything discussed today is fine. And if something is going against the principle of equality, it has to be challenged in the court of law by somebody who has the locus standi. Unless something is challenged, it will still stand, because that's how, unfortunately, it is, that unless you challenge something in the court of law, it just stands there. So even if it is going against the principle of equality, it still stands there unless it is declared unconstitutional.
Shanu is raising her hand. I'm unmuting you, Shanu. You can ask the question. Shanu.
So now I'm asking that if something is passed by the legislative and then it is being cancelled by the Supreme Court, so is that the final decision, or it can go somewhere else from there also?
Supreme Court is the final thing. There is nothing beyond the Supreme Court in India. There are appeals, of course. There's first it goes to a single bench, then it goes to division bench, then there are constitutional benches. The judges form different benches. There's 5 bench, 9 bench. There are 15 bench benches as well, 15 judge benches as well. But Supreme Court is ultimately.
Saurabh, I'm unmuting you. Saurabh.
Am I audible, ma'am?
Yes, yes.
Ma'am, ma'am, I am a student of law at Delhi University. Ma'am, in this semester, I have a subject, this Constitution of India. Ma'am, what would you recommend that how to read and how to understand this subject, ma'am? Because we are new in this field.
Yeah, as I said earlier, you have to read the commentaries. So the best 2 books which I recommend are B.A.LLB Constitution of India and MP Jain Indian Constitutional Law. So these are the 2 books which I recommend. Start by reading these books, read the case laws, and when you find time, you can go through the entire cases. Some of the cases are pretty huge, but they're worth it at times. At times they're not. But you can, if you know how to find the ratio of the decision, that should be enough. You don't have to read the obiter part of it.
Preethi, Harshvina is asking book suggestion to understand what law is for the beginners.
What law is?
For the beginners.
What law is? Wow, that I'll have to look up for that. Just generally about law, I'll have to look up for that. I can't. A.V. Dicey is good, but he's basically talking about rule of law. But just generally about what law is, I'll have to look up for that. Maybe next class I will say.
One more question is there. Pranav is asking, among the different constitutions in different countries, which constitution seems to be the most progressive and democratic?
I'm really sorry, I haven't read all the constitutions of the world, so I can't really comment on which of them is more progressive and democratic. No, I really can't. That's a really, really big question. There are 190 odd countries, and I haven't read all those constitutions, so I really can't comment on that. How can you pursue law after BTech? You can enroll to any of the 3-year law course in any of the universities. And if you're under the age, I don't know the present age for CLAT, maybe 20, I think. So you can, if you're under that, you can apply for CLAT and join for 5-year course. They are the two options you have. So it's either 3 years or 5 years. 3 years is more flexible, and most people after bachelor's go for 3 years course in law. There might be private universities which give a 5-year course for people below 30. I don't know. I really don't have an idea. Sorry. 19. I think you can appear for CLAT. I think you can. I really don't know. I took CLAT over a decade ago, so I have no idea what the rules are now. Sorry. Yes, no, nothing.
You can raise your hands or write in the chat box on YouTube, anywhere. Mayuri is asking, can you please explain once again what constitutionalism is?
Right. So constitutionalism is basically limited government or limitations that are placed on government. So that's in a single line I'm telling you, it's the limitation placed on government. It is basically the antithesis of arbitrary powers. So it recognizes the need for government with powers, but there has to be limitations on that. So we'll wrap up. Yes, no, thumbs up, something. So I'm not. Is that a question? Vidisha?
Vidisha, you can unmute yourself. Yeah.
Ma'am, while explaining state, you mentioned that a state must have 4 things. Can you please repeat that?
Yeah, it's according to Montevideo Convention of 1993. There's Article 1 under the convention. So there has to be a permanent population, a defined territory, a government, and the capacity to conduct international relations with other states. It's under Article 1 of the Montevideo Convention on the Rights and Duties of States. So this convention basically lays down the criteria for statehood. So we'll wrap.
We can wrap up, Preethi.
Yes, great. Thank you so much, guys. And what was it? Yeah. Thank you so much for being here. I'll see you all next week at 7. And yeah, bye. And who conducted the session? I mean, Nilesh, was it you?
Yes, I am. I'm here.
Hi.
Hi.
Hi. Right. Thank you so much.
Thank you everyone for joining. We'll meet you next week at 7 o'clock. Please be there. Thank you everyone for joining.
You guys, thank you.